Good evening, everybody. I'd like to welcome you all to the July 18th meeting of the Milford Planning and Zoning Board. If we could please stand for the Pledge of Allegiance and a moment of silence. Meg, if you would please call the roll. Excuse me.
Ms. Austin.
Present.
Mr. Casador.
Here.
Mr. Hirsch.
Here.
Mr. Cater.
Present.
Mr. Collegian.
Present.
Mr. Sadi.
Present.
Mr. Zaharidis.
Present.
And Chairman Quish. And Mr. Mortimer is excused.
I'm also here, okay. Our first order of business is an executive session. Sorry to the crowd, it shouldn't take us too long, and I would invite the city attorney and the city planner. And Mr. Griffith. Thank you all for your patience. Our regular meeting is back in session. Next order of business is 88 Elder Street, Zone R75, petition of Alan Shepard, NOK Associates, for a coastal area site plan review to construct a single-family dwelling on map 035, block 429, parcel 3, of which Howard and Stephanie Krieger are the owners. The applicant has the floor.
Good evening. I'm Alan Shepard, professional engineer, partner in the firm of Nowakowski of Beavertown, Kane, 415 Howe Avenue, Shelton, Connecticut. And what we have in front of you is a proposal. There was a house on the property, it's got knocked down. We're going to rebuild in the same, almost the same footprint, but we are in the coastal management jurisdiction, even though it's across the road. So we have prepared a site plan that shows minimum amount of grading. So we're going to use the same, basically the same driveway grades, same house location. And
Excuse me, was that site plan delivered to
Yes.
all the members?
you should have copies.
Yeah, Mr. Chair. Yeah, it would be in the link that was sent to you.
Right, but no paper copies.
No, no paper copies.
Okay, proceed.
I do have copies in case anybody wants to look at it full sheet. Basically, what we're doing is providing stormwater recharge for water quality volumes. We looked at also stormwater detention, and they're almost equivalent, so we went with recharge because we feel that's better for the site, because we're so close to the sound. And the soils are pretty good soils out there, so I think, you know, it should be a straightforward build out.
Okay, thank you. David, if you'd like to give your overview.
The applicant is proposing to construct a single-family dwelling of approximately 4,200 square feet and 30 feet in height. No adverse impacts to coastal resources are anticipated. The project is substantially zoning compliant. The city engineer is concerned about a potential for stormwater or footing discharges causing offsite issues if the plan is not implemented exactly as provided. The city engineer's letter dated June 28, 2023 should be made a condition of approval.
Thank you for that. Are there any questions and comments from the board? Seeing none, I'd hear a motion. Mr. Sadi.
Thank you very much, Chairman Quish. I move to approve with the following modifications: the 3 comments on June 28, 23, letter of the city engineer regarding the petition of Alan Shepard, NOK Associates, for a coastal area site plan review to construct a single-family dwelling at map 035, block 429, parcel 3, of which Howard and Stephanie Krieger are the owners.
Second.
We have a motion and a second. Any discussion on the motion? Seeing none, Meg, please call the roll.
Ms. Austin?
With the motion.
Mr. Cassignoli?
Yes.
Mr. Hirsch?
With the motion.
Mr. Cater?
With the motion.
Mr. Collegian?
With the motion.
Mr. Sadi?
With the motion.
Mrs. Zaharidis?
With the motion.
And Chairman Quish.
I'm also with the motion. Good luck with your project.
Thank you.
The next order of business is the draft Plan of Conservation and Development, or POCD. A board decision on this tonight will be for the purpose of referring it to the other stakeholders, the South Central Regional Council of Governments and the Board of Aldermen for comment. Once that comes back, we will then have at least one public hearing to get further public input on the POCD. David, if you would give whatever points you'd like to put out for tonight's meeting.
Yes, the plan that you have received now 2 copies. The original copy, which you got before we had the 2 public hearings, and a new copy that was updated to reflect comments made both at the public hearings and submitted in writing to the office. So we think that we addressed those comments appropriately in the POCD as it stands right now. And unless you have any particular questions about the document, as you said, we'd like permission tonight to circulate this to the Council of Governments and the Board of Aldermen.
Okay, thank you. Are there any questions or comments from the board at this point? We do have Adam, who represents our consultant who worked on this with us, had thought this was a Zoom meeting, and he's out of the state. So
He is listening. I have him on speakerphone.
yeah, he is available for questions via phone if anyone has a specific question for him. If not, we can hear a motion.
Mr. Chairman,
Yeah, go ahead.
I'll move to refer the draft POCD to the South Central Regional Council of Governments and the Board of Aldermen for their comments.
We have a motion. We have a second.
Second.
Motion and a second. Any further discussion? Seeing none, Meg, if you would call the roll.
Ms. Austin?
With the motion.
Mr. Cassiano?
Yes.
Mr. Hirsch?
With the motion.
Mr. Cater?
With the motion.
Mr. Collegian?
With the motion.
Mr. Sadi?
With the motion.
Mr. Zaharidis?
With the motion.
And Chairman Quish.
I'm also with the motion. Thank you. Next order of business are the public hearings closed by August 22nd, vote by October 26th. Proposed regulation change 22-9, petition of the Planning and Zoning Board for a change to Milford zoning regulations, Article 6, Section 642, use of non-conforming lots when applicants are predecessor-owned adjacent land, and Section 644, state statutes. If you would, David, provide us with just a small history as well as the meat and potatoes of the change in language.
Okay, so just to give a brief history, we had a regulation called 642 that merged non-conforming lots when the person who owned it or their predecessors owned both of those lots. In our old 642, it was incumbent on the owner to prove that their lots were never merged, were never used in any way that would have merged them for a lot to be used, which sometimes was easy, sometimes wasn't. But in any event, we had that at that point in time, and a couple of years ago, the board thought that, well, maybe we don't need this regulation at all. So the board removed it, and the result of that is that lots that were created prior to 1929, lots that were created also after 1929 that had been merged either by a house being on them or a pool, or not merged at all of a sudden became unmerged. So we started to see a flood of applications coming in where people were tearing down houses that were on lots that had been merged to then build more houses, multiple houses, increasing the density, which was considered problematic by many neighbors who started to visit the office and complain to board members. So the result of all of this was to create a new 642 regulation that would remove the onus on trying to on the people who own the lots and staff to try to figure out, well, was it merged, wasn't it merged? So what we're doing is we're proposing a method that is used around the state and other municipalities that have this issue, which is merger by operation of law. And what 642 is merger by operation of law that just simply states, hey, you have these two lots, they're non-conforming lots, you own both of them, well, now they're going to be merged, so you have a conforming lot. And it's more or less as simple as that.
Thank you for that. Are there any questions or comments for the board before I open it up to the public? Etan.
Mr. Zalkis, so if I understand correctly, the purpose of this new regulation is to reduce the number of non-conforming lots in the city of Milford.
Yes.
Any other questions or comments before we open this to the public hearing? Seeing none, this is a public hearing. It's open. If you have anything you'd like to share, please come to the podium, state your name and address for the board, and try to keep your comments to about 3 minutes.
Good evening, everyone. The last time I was up here, I had trouble getting across because I wasn't close enough to the microphone. My name is Attorney Robert Maslin. I am a zoning attorney by primary practice. My office is at 30 Old Kings Highway, Darien, Connecticut, 30 Old Kings Highway South, Darien, Connecticut. And I'm here representing the Board of Managers of the Laurel Beach Association. And John Shanley, who's chairman, is here with me this evening. He asked me if I would come and offer some commentary on the proposed regulation. And so what I did was I wrote a letter, submitted it by email to the planning email where you register to speak. I don't know if that process still applies now that meetings are back in person, but I have quite a few copies here for the board. If I can hand them to somebody, I just don't know where to.
Right, if anybody has an objection, they don't have to take one, but I'm willing to take one. If you want to come up and pass them out,
Sure.
that'd be fine.
Okay, while it's being passed down, I'll just touch on the more significant points in my letter. But I'm here both in favor of the proposal to adopt a regulation to resolve this merger issue, but we think there's a better way than the proposed language that's before you this evening. I'll start at the end. Proposed 6.4.4 is fine. 6.4.4 codifies into the zoning regulations the protections for non-conforming lots that were previously approved by a formal subdivision process under subdivision regulations and a review and decision process involving a planning commission. And those are set forth in 3 statutes primarily, sections 8-26A and 8-28A and 28B. And in essence, what they say is that once a subdivision lot is approved by that subdivision approval process, subsequent changes to subdivision and zoning regulations do not apply to those lots. The one exception that's occurred in the last 10 or 15 years as a result of a case called Poirier, which is a Wilton case. 8-26A was modified so the protection applies only to lot configuration requirements and the first building that goes on the lot. In other words, if you have a vacant lot that hasn't been previously developed, and that means no building permit and no foundation was built, then the original zoning regulations from whenever that subdivision approval occurred apply to construction on that lot. And what the legislature did was change that so that you get to do that once, if you put an addition on the house, or you knock the house down, you build another house, then you have to comply with the current regulations. But as far as lot area, lot depth, lot width, that all is cemented in and protected, and it only applies to residential lots. Now, with respect to 6.4.2, the primary issue here is the proposed regulation simply says the lots merge, but it doesn't say what's next. You can have 2 or 3 lots merge because they're owned in common ownership, and one or more of them is non-conforming. So the idea is you merge them so that you end up with a lot that's less non-conforming. The problem is, what do you do next? Now you end up with a little less non-conforming lot, but do you get a zoning permit? Do you qualify for a zoning permit? Do you still have to go to the Zoning Board of Appeals to get variances in order to build on the lot? It's not really clear. 6.4.1 starts with the language, a zoning permit may be issued if, and there are conditions, which is the way that most regulations that I'm familiar with on the question of merger work. If you have an old non-conforming lot, it's never merged, or you meet the conditions in the regulations, then you can get a zoning permit, which is the next step before getting a building permit, and you can develop your lot. The problem is what's proposed for 6.4.2 doesn't have that zoning permit process as the next step. And it leaves open the question, what do we do now? Now we have merged lots. What's next? So my suggestion is, our suggestion on behalf of the board, is to combine the two so that you wind up with one regulation that says a property owner is entitled to a zoning permit if, and there's a list of conditions. And on page 3 of my letter, the conditions are, and these are conceptual, you can modify them, we can talk about it, you can decide to ignore everything I say, and that's another story, but the conditions are basically, number 1, the present owner or predecessor owners entitled did not illegally create the lot. Well, that's already in 6.4.1, and I think it was in 6.4.2 before it was repealed. Number 2, the present owner or predecessors entitled did not or does not own any land adjacent to the lot which was caused to become nonconforming by virtue of revised regulations. That's the merger. And it's simple ownership. You're not getting into how did you use the lot? Did you merge it by use? Is it a common law use? If the lot had been owned by the same owner anytime during the lot's history, the two lots merge. And what that does, it means you can't get a zoning permit for that initial non-conforming lot, so they merge. Number 3, which is already in the regulation, all yard setback, coverage, and other requirements are met. That's already, as I said, in the regulation. I believe it was in the regulation, the other regulation before it was appealed. And 4 is kind of obvious. The lot was never sold by the city with a stipulation or restriction that would prohibit its use as a separate building lot. Again, that's already in the regulation. By putting in number 2 as a condition, you can combine both 6.4.1 and a 6.4.2 into a single regulation. The merger part's built into it. And if you qualify, if an owner qualifies, then the next step is to get the zoning permit. It's simple, it's efficient, and I think it accomplishes your goal without leaving open the question, now that you have merged lots, what do you do next? A couple of other points. Now, I don't practice zoning in Milford, so you have to excuse my ignorance on some of these things, but there seems to be a custom where a property owner or a developer can apply to the zoning enforcement officer to get a, quote, certification with respect to a non-conforming building lot.
Yeah, we do have kind of a policy for 3 minutes. I think I've given you
Yeah.
quite a bit of leeway, and if you would button it up, and if anyone has a question, I'll allow that to come in front of you so that we do actually have very precise language in front of us.
Yes, the
and-
letter's here. So
No.
Yep.
This is a hearing based on what the language we've
Okay.
already done. So I understand what you're saying.
Sure.
If you could wrap it up, and then anybody can ask you a question
Sure.
after that if they want to.
Okay,
Thank you. Yep.
my final point is, the practice now is to have an attorney who is not the zoning enforcement officer make some verification as to the history of the lot. And there doesn't appear to be a formal process in the regulations for that, and there doesn't appear to be a review process where someone, A, finds out about that review or certification or verification and has an opportunity to challenge it. We think, and I think as a matter of zoning law, the final decision should be up to the zoning enforcement officer without delegating the verification to a developer's attorney. And that way you get a more, I think, a more appropriate, more independent review of the history of the lot and the certification as to the non-conforming status. Those are my primary points, and the rest is in my letter. You can.
Well, thank you. I appreciate that. Just as a point of disclosure, I am a member of the Laurel Beach Association. I live there. I will sit through this, and I don't see any particular financial interest either way with it. So I feel that I'm not swayed either way, for or against, with relation to your presentation.
If I may, sir, this is a legislative decision, and it applies to the regulation as being proposed for the entire city of Milford. It's not specific. My comments are not specific to Laurel Beach.
I understand that.
You're
I just
fine.
wanted to make my disclosure
You're fine.
that I am a member of Laurel Beach. That's all.
Yeah.
Thank you.
You're fine.
Sadie?
Thank you again, Mr. Chair. I'm in the same position of the chair. I am a member of the association and received no notice that they were appearing here before this board today, but I don't think it will prevent me from listening to this.
I agree.
Is there anyone else that would like to speak?
Any questions?
No. Well, it's a public hearing at this point. Hello, if you would just state your name and address for the board.
Sure. Donna Dutko, 236 Buckingham Avenue. And I know you folks have been working on this for some time. I think that the root of the problem was residential lots. Your biggest concern was people building houses right next to other houses. So I was wondering, since that has been the biggest complaint, I would assume that you'd want to only apply it to residential districts and not the CDD districts or other commercial districts. It doesn't seem to fit the issues going on in residential districts and apply them to the other zones.
Your interpretation is correct. This is residential only.
It doesn't say that.
That would be incorrect. This is for the whole city as it was before. It's all zones. It has to be uniform.
Oh, I stand corrected.
So why wouldn't it be just residential and not other?
Yeah, this, unfortunately, this forum is really not designed for questions from the audience. I'll ask the question of the city planner after you're finished, but you're welcome to continue.
Okay, well, that was my whole point. I hadn't heard any complaints, and you know me, I always listen to the zoning hearings and stuff, and it's always about residential properties. So I think that to look at commercial properties and lump them into this regulation could be, I don't know if you've even explored the commercial properties issues, so
Thank you.
you're welcome.
Are there any other people who would like to speak? Any questions or comments from the board for the city planner, or through the city planner to anyone in the audience? David, if you would, again, most of the conversation that we've had and most of the problems that we've had were residential. And funny how I thought this was specifically residential. My bad that after a year of this battle, I was unaware. So if you would speak to the effect on what you could see as a potential effect on other properties, CDDs or commercial, all other zones, and how this has, the change in regulation, has that affected other zones, and would you expect this change to affect other zones?
The previous regulation that we had was for the entire city. As it happens, the issues seem to be, as everyone has observed, mostly in the residential zones. It hasn't been an issue in most of the commercial zones. Most of the commercial properties are of such a size, depending on the zone, that they, for the most part, meet the minimum requirements, and often you don't have adjoining parcels that are owned by the same owner. So I don't see it as an issue. It wasn't an issue before we got rid of 642. I don't see it being an issue after. The other thing to keep in mind is a lot of the commercial zones were created in 2004, the regulations. That's when we created our commercial corridor zones, which took into account the average size of zones and parcels that were in those zones. Whereas the R zones have been around for a very long time, and again, as you know, as a resident of Laurel Beach, you have smaller properties, and in some cases, many more undeveloped properties that are within the residential zones.
Are there any further questions? I actually would like to keep the public hearing open and read the document that was provided, and I have never considered this regulation as having any other impact except for residential. So that's, again, the only conversation we ever had in any of our subcommittee meetings. Never once was it brought up that it was any other zone. So it was my bad for missing that, and I would like to consider that, read the zoning regs again, and take this information that we got today and study it.
Just for Mr. Chair, because it's not an issue in the commercial zones. It never was before nor after, although the regulations apply to all the zones in the city, both residential and commercial.
Thank you. Again, I'd like to keep the public hearing open and consider what we received today, and consider the implications of this, what I consider new information to me. If that's fine, if not, somebody can make a motion.
Mr. Chair, are you proposing that we, well, let me go back. So we have two options. We could leave the public hearing open, or we could take a vote today to approve this new regulation change. And your proposal, Mr. Chair, is that we leave this open for the next meeting in August and come back.
That is correct.
And the reason why you indicate you want to come back in 2 weeks is because you want to research the potential impact on commercial zones by this regulation.
Actually, no, I just want to, I just got this letter today, so I just want to read it and try to understand it. And if I want to reread our zoning regulations, then I will do that. Brian?
I ordinarily hate delays, and this time I think it's super appropriate. I'm especially curious about paragraph 2 on page 3. And before I think that we should leave the public hearing open. While he's here, if we could just have him come up and open back up.
That's perfectly okay with me.
Thanks. Attorney Maslin?
Yeah, you're welcome to come up, and if you would put your questions through either me or the city planner.
I'll go through you, Jimmy. I'd like to have the attorney for that testified earlier reread section paragraph 2, numbered paragraph 2
on page 3. And just tell me again what that stands for. I think I know what it is, but I'd like to hear it again.
The condition number 2 would function as the merger provision. It says the present owner or his predecessors in title did not or does not own any land adjacent to the lot, meaning the substandard lot. If it turns out that the answer to that is yes, then the lot wouldn't qualify as a separate building lot. It would, in effect, merge with the adjacent lot.
So I'm not going to ask.
That's the merger.
I'm not going to ask your opinion about this, but I would state that what I've heard leads me to think that it means that it would prevent some finagling from going on to have, all of a sudden we've got a lot that may not be conforming, but the guy next door, but the guy that's presenting the lot that's slightly non-conforming, a little bit more conforming than it was, but still not conforming, doesn't have in his pocket more land that he could use to make it conforming. So it eliminates some of that hanky-panky, if you would. That's my opinion. I'm not asking you for yours. Thank you.
Mm-hmm. Well, just to follow up on that, this is a policy issue to begin with. So most of my commentary here is directed toward helping you make a regulation that's going to be efficient and avoid confusion and avoid, as you use your words, hanky-panky with people and monkeying around with their parcels.
Thank you. Etan.
The issue, as I read this paragraph 2, the phrase, since the lot was caused to become non-conforming, caused by whom? It's used, the word cause is used in the passive voice. I'm a little confused. You're not saying caused either legally or illegally, just any cause?
Well, the next part of the next language says, by virtue of revised zoning regulations. And this doesn't address common law merger, but common law merger is still out there. But what makes a lot non-conforming is a lot that complies when it's made, and then in the future, the zone is changed, and you go from a half-acre zone to a 1-acre zone. That half-acre lot that used to conform no longer conforms. That's the gist of this.
Thank you. Mr. Sadi.
Thank you, Counsel. Do you represent the Laurel Beach Association in their lawsuits at the Zoning Board of Appeals in any Superior Court actions?
I have one case now that we just recently went to the Zoning Board of Appeals on. We appealed one of those certifications by the zoning enforcement officer. The legal notice hasn't been published yet, and I haven't filed an appeal yet on that. Other than that, no, I don't.
Could you explain why you didn't tell us that before you proposed something that's going to assist your legal lawsuits that you have pending?
I don't understand your...
The proposal that is being submitted by the zoning board is that other than non-certified, lots that have already been certified would be allowed to keep their certification. You take that out, and that benefits you and your client in the pending lawsuits.
I don't think it does, because one of the things that's at issue is the certification itself, because there's no provision for certification.
Oh, we're going to differ on that. I just felt it was important. You should have told us that you represent them on matters before the Zoning Board of Appeals and also apparently a Superior Court appeal. Thank you.
Any other questions or comments? Okay, this matter, without objection, will be, the public hearing will be held open, and we will hear it at our next in-person meeting. Okay? Thank you for your time. Our next order of business is 242 Buckingham Avenue, Zone CDD4, petition of Molly Rentals LLC for a special permit to construct a dwelling unit residential complex at map 55, block 545, parcel 6, of which Tom Haynes is the owner. Oops, I'm sorry, that's postponed. Should have read that first. Looks like our business here is just about done. No old business. Liaison report?
No, Mr. Chair.
Okay, subcommittee reports. We have just agreed to send the POCD back, and we are seeing the end of one of our regulation subcommittee issues. We don't have a scheduled regulation subcommittee meeting, but you will be informed as soon as we have one. If I could, please have a motion to approve the minutes. Without objection, minutes are approved. Chair's report, I have none. Staff report?
None this evening.
Okay, thank you. Without objection, we're adjourned.